The Fair Labor Standards Act established certain workers' rights, including the right to a minimum wage set federally at $7.25 as of 2020, and overtime pay for all hours worked over 40 in a work week for non-exempt employees. However, some employers try to cut costs by denying workers their rightful pay through deceitful methods. This is called wage theft and includes examples such as paying a worker less than the federal minimum wage, giving a worker comp time or hours that can be used towards vacation or sick time rather than overtime pay for hours worked over 40 in a work week, forcing tipped workers to pool their tips with non-tipped workers such as managers or cooks, forcing workers to pay for tools of a trade or other expenses that their employer should pay, and misclassifying a worker that should be paid overtime as exempt by promoting them to managerial positions without actually changing the worker's job duties. Some of the most vulnerable occupations to overtime and minimum wage violations include IT workers, service technicians, installers, sales representatives, nurses and healthcare workers, tipped employees, oil and gas field workers, call center workers, personal bankers, mortgage brokers, and anti-money laundering analysts, retail employees, exotic dancers, FedEx drivers, disaster relief workers, and pizza delivery drivers. Under the Fair Labor Standards Act, all employees must be paid at least the federal minimum wage of $7.25 an hour. However, some employees mistakenly or intentionally pay their workers less than minimum wage. Tipped employees such as waiters, busboys, and bartenders can be paid a lower tipped minimum wage as long as they receive at least the minimum wage when the money they earn in tips is taken into account. When tipped employees don't make at least the minimum wage between their tips and hourly wages, they're entitled to minimum wage makeup on their paychecks. Furthermore, tipped employees are the only ones who can take part in a tip pool. When non-tipped employees, such as chefs and managers, take money from the tip pool, the tip employee's wages may fall beneath the minimum wage. When an employee's hourly rate amounts to less than the minimum hourly rate, the employer is responsible for paying her a minimum wage makeup in the employee's paycheck. The Fair Labor Standards Act prohibits off-the-clock work. Employees must be paid for all work-related activities, including time spent attending meetings and training sessions, putting on and taking off protective gear and clothing, booting up computers, cleaning equipment, and taking short breaks that last between 5 and 20 minutes. When employers fail to pay workers for all the time they spend working, their hourly rates may fall below the minimum wage, and they may even be cheated out of overtime pay. Day rate workers are paid a set amount for each day of work, regardless of how many hours they work. This is generally legal as long as workers' hourly rates remain at or above the minimum wage. Because this type of pay is commonly used in the oil and gas industries, where employers work 12 to 16-hour days, these workers may be particularly at risk for minimum wage violations. One employee has to pay for certain work-related necessities, for example, required uniforms, dry cleaning costs, physical exams, cash register shortages, etc. Their hourly wage may end up falling beneath the minimum wage. Misclassification can be an unfair labor practice. There are a number of differences between employees and self-employed workers, also known as independent contractors or consultants. Unlike employees who are told when and where to work, guaranteed a regular wage amount, and entitled to employee benefits, among other criteria, independent contractors generally work on a short-term contract basis with the business and are invoiced for their work. Independent contractors aren't entitled to employee benefits and must file and withhold their own taxes as well. However, in recent years, some employers have abused classification by misclassifying bona fide employees as contractors in an attempt to save money and circumvent laws. This is most commonly seen as gig economy workers, such as rideshare drivers and delivery drivers. Some examples of misclassifications include misclassifying a worker as an independent contractor to not have to comply with Equal Employment Opportunity Commission laws which prevent employment discrimination, misclassifying a worker to avoid enrolling them in a health benefits plan, and misclassifying employees to avoid paying out minimum wage. For years, companies have been abusing their workers to save money by cheating them out of living wages and other benefits by labeling them as independent contractors. If you are a victim of unfair labor practices, contact the Law Center to be connected to a partner law firm in our network near you for a free, no-obligation case review today.